I note that a quorum is present. Without objection, the chair is authorized to call a recess at any time. Today's hearing is about protecting the retirement savings of American workers and employers who voluntarily maintain retirement savings and other employee benefit plans from baseless predatory class action lawsuits. Employer-sponsored retirement plans are the backbone of the American retirement. Employer-sponsored health care and other plans provide important benefits to American workers and their families. The Employee Retirement Income Security Act, ERISA, helps protect retirement, health, and other benefits for more than 155 million workers, retirees, and their family members. Altogether, these plans hold more than $14 trillion, helping millions of Americans save for the future and stay financially secure. These assets represent the savings and contributions of workers and their employers. But make no mistake, such a large pool of assets is attracting predatory lawyers who are targeting employee benefit plans for easy, quick money, sue and settle lawsuits. Under the Biden-Harris administration, inflation and the cost of living rose dramatically, throwing many Americans into financial jeopardy. On top of that, predatory class action attorneys are targeting employers who fund retirement, health, and other workplace benefits for their workers, putting jobs and financial security at risk. In stark contrast, committee Republicans have been working to ensure that American savers are protected. My bill to ensure that investment fiduciaries are focused on maximizing returns for ERISA plan investments rather than on woke ESG factors passed the committee earlier this year. Congressman Fine has introduced legislation with solutions to the problems we will hear about today. I look forward to discussing this bill and other efforts to protect ERISA plan participants and their benefit plans. I want to thank our witnesses today who have frontline experience fending off meritless quick money lawsuits from class action attorneys. We will hear today how benefit plans, the employers who offer them, and plan managers are being targeted by attorneys looking for big payouts. We'll also ask an important question. Are these lawsuits helping American workers or just lining the pockets of trial lawyers? We'll also hear how these lawsuits are changing the way ERISA plans work and what that means for the benefits that American workers rely on. With that, I yield to the ranking member for an opening statement.
Thank you, Mr. Chairman, and thank you to our witnesses for being here today. Workers deserve to earn a decent wage, provide for themselves and their families, and retire with dignity. It's the American way when we do it right. But right now they are facing an economy that isn't working for them and for most Americans. Jobs numbers released last month show that the Trump administration presided over 2 consecutive months of job loss this year while consumer prices continue to go up. This represents the first monthly job losses since the first Trump administration. At the same time, we remain deeply concerned about the subcommittee's agenda, particularly its focus on prioritizing the interest of corporations over American workers and their retirement security. Excuse me?
You're out of time.
Apparently something's going on about my security system 3,000 miles away, but I'm sure it's not you, Mr. Chairman. Probably Mr. Wahlberg. In July, the subcommittee held a hearing examining the Department of Labor's Employee Benefit Security Administration, known as EBSA, pronounced EBSA, which is a vital agency that protects workers' hard-earned health and retirement benefits. Regrettably, EBSA has remained underfunded and understaffed for years, and the Trump administration's fiscal year 2026 budget only makes things worse. Against this backdrop, the subcommittee is seeking to undermine retirement savers' legal right to obtain justice in court. No one wants frivolous lawsuits, but if we follow the regulations and fund the investigators and the enforcement arm, we wouldn't have to deal with lawsuits. Under the Employee Retirement Income Security Act, known as ERISA, workers have a legal right to bring claims in federal court. Over the years, workers have filed cases alleging misconduct by retirement plan sponsors, such as charging excessive fees or offering risky investments, which can sharply reduce workers' retirement savings. I expect this morning's hearing will focus on the recent Supreme Court case entitled Cunningham versus Cornell University. This case involved 28,000 plaintiffs who alleged that their retirement plans paid several times more in fees than they should have paid. The technical issue in this case was whether plaintiffs need to allege more than that a violation occurred to survive a motion to dismiss. The Supreme Court unanimously ruled that they did not. This ruling ensured that the very point of ERISA, to protect benefits, is realized. In the months that have followed the Supreme Court's unanimous decision, there has not been any spike in ERISA litigation as some feared. One major law firm that defends corporations acknowledged that the decision, quote, has not yet resulted in material increase in record-keeping fee challenges or ERISA excessive fee lawsuits, close quote. Based on the title of today's hearing, I suspect we will hear a lot about so-called frivolous ERISA class action litigation. According to the Congressional Research Service, there were 586 class actions filed between 2020 and 2024, which represents just a minuscule fraction of the over 800,000 private sector retirement plans. Yet despite these facts, committee Republicans recently introduced legislation that functionally overturns the unanimous Supreme Court decision in Cunningham versus Cornell. It makes it more difficult for workers and retirement savers who have been ripped off to get their day in court. This is wrong, Mr. Chairman. We should instead strengthen and expand ERISA's fundamental protections. We should ensure that workers and retirees are empowered to stand up for themselves and their families if denied the health care benefits they deserve. For example, I previously introduced the Employee and Retiree Access to Justice Act, which would ensure that individuals have meaningful recourse when they are denied retirement and health benefits, including mental health and substance use disorder treatment under an employer-sponsored plan. This is the kind of meaningful solution that workers' retirement plan participants want from us, not policies that make it more difficult for them to seek justice. Mr. Chairman, I'd be more than happy to work with you on your bill and my bill to see if we can avoid inefficiencies in American workers getting the pension plans that they paid into and their employers contributed to. Thank you. I yield back.
Thank the ranking member. Pursuant to Committee Rule 8C, all members who wish to insert written statements into the record may do so by submitting them to the committee clerk electronically in Microsoft Word format by 5 p.m., 14 days after this hearing. Without objection, the hearing record will remain open for 14 days to allow such statements and other extraneous materials noted during the hearing to be submitted for the official hearing record. I will now turn to the introduction of our 4 distinguished witnesses. Our first witness is Mr. Andrew Salakram, a principal at Groom Law Group here in Washington, D.C. Our second witness is Mrs. Lynn Dudley, the Senior Vice President for Global Retirement and Compensation Policy at the American Benefits Council in Washington, D.C. Our third witness is Mr. William Alvarado Rivera, the Senior Vice President of Litigation at the AARP Foundation in Washington, D.C. Our last witness is Mr. Glenn Budish, the Chair of the ERIC Legal Center for the ERISA Industry Committee in Washington, D.C. And thank you again for being here today. We thank our witnesses and we look forward to your testimony. Pursuant to committee rules, I would ask that each of you limit your oral presentation to a 3-minute summary of your written statement. As committee members have many questions for you, the clock will count down from 3 minutes. Pursuant to Committee Rule 8D and committee practice, however, you will not be cut off your testimony until you reach the 5-minute mark. I would also like to remind the witnesses to be aware of their responsibility to provide accurate information to the subcommittee. I now recognize Mr. Salakram for your testimony.
Good morning, Chairman Allen, Ranking Member DeSaulnier, and members of the Subcommittee on Health, Employment, Labor, and Pensions. My name is Andrew Salakram. I'm a principal at Groom Law Group, a law firm specializing in all aspects of employee benefits. I'm the practice group leader for Groom's ERISA litigation group, where I have represented ERISA litigants for over a decade. In enacting ERISA, Congress sought to strike a balance between protecting employee retirement benefits and incentivizing employers to offer them. That balance has grown askew in the context of ERISA litigation, where an explosion of meritless class action lawsuits has cost plan sponsors, fiduciaries, and service providers hundreds of millions of dollars in defense costs and settlement payments, and enriched the class action plaintiffs bar at the expense of American workers. A low pleading bar is the main culprit. Before a lawsuit can proceed to discovery in federal court, the plaintiff must meet his or her pleading burden, that is, must plausibly allege that a defendant committed wrongdoing. Unfortunately, courts too often hand ERISA class action plaintiffs the keys to discovery based on innocuous allegations. For example, allegations that a 401k plan paid a service provider for necessary services, or that an employee stock ownership plan purchased employer stock from the company's owner can be enough to state a statutory breach. Of course, ERISA 401k service provider engagements and ESOP stock purchase transactions are commonplace and, in fact, necessary to the very existence of both types of plans. Congress, in creating ERISA's careful balance, did not intend for retirement plan sponsors, retirement plan fiduciaries, and parties to ESOP transactions to spend years and millions of dollars defending a lawsuit simply because they established and administered a retirement plan. Common sense legislation is therefore necessary to ensure that ERISA plaintiffs are required to plead something rather than nothing. Without such a course correction, an opportunistic plaintiffs bar will continue to carry meritless suits past the pleading stage, where asymmetric discovery obligations require class action defendants to spend millions of dollars just to have the opportunity to argue the merits. These astronomical costs push defendants into cost of defense settlements to buy peace, regardless of the strength of a plaintiff's case. This is especially true for litigation involving plaintiffs' firms that abuse the discovery process to increase the baseline cost of defense and ratchet up settlement pressure. Tactics include suing a large number of unnecessary defendants to financially stress the indemnitor sponsor company, suing the family members of alleged fiduciary defendants, including in a recent instance an infant, and issuing voluminous and unduly burdensome written discovery. The risk that tolerating costly meritless lawsuits will lead to less lucrative benefits or to no benefits at all for American workers is not academic. For example, it's happened in the ESOP space, where certain courts have long held that a plaintiff alleges a statutory breach by claiming that an ESOP did what it was designed for, simply purchasing employer stock. Companies who wish to establish ESOPs regularly cite litigation risk as a reason they have not done so, and those that have established ESOPs bear skyrocketing fiduciary insurance costs that are ultimately borne by their employee owners. In acquiescing to a low pleading bar in its recent Cunningham versus Cornell decision, the Supreme Court acknowledged the, quote, serious concern that its holding would contribute to, quote, an avalanche of meritless litigation. Unfortunately, ERISA's text tied the court's hands, and while the court identified tools available to lower courts that could help to eliminate meritless claims, the consensus is that these judicial mechanisms have been and remain inadequate. Legislative action is thus necessary to revise ERISA's text and help to restore an appropriate equilibrium between allowing meritorious claims to proceed while filtering out frivolous ones. Thank you, and I look forward to your questions.
I now recognize Ms. Dudley for your testimony.
Thank you, Mr. Chairman, and thank you, Ranking Member DeSaulnier, and members of the subcommittee for being here today and allowing us to share our views from the American Benefits Council. Right now, the top retirement policy issue for our plan sponsor members is the tidal wave of inappropriate and, yes, indeed, frivolous litigation that is draining resources away from benefits, inhibiting innovation, preventing many new products and services from being offered and benefiting only plaintiffs' lawyers. We strongly support the committee's attention to this crisis and Representative Fine's bill, which would override a Supreme Court decision in Cunningham versus Cornell University that even the court admitted was not the right answer. I'd like to make three important points today in my testimony. First, the tidal wave of litigation is hurting plan participants. We conducted an informal survey of our plan sponsors and found that almost 89% of defined contribution plan sponsors report that the risk of litigation is a very or somewhat significant factor affecting their decisions to enhance services or provide different investment options. Second, only the plaintiff's lawyers are really benefiting from the litigation. For example, from the period 2009 to 2016, attorneys representing plaintiffs in a breach of fiduciary duty lawsuits are estimated to have collected roughly $204 million for themselves, while securing an average per participant award of $116. And it's gotten a lot worse since 2016. Third, the Cornell case, which the fine bill would override, will make a terrible situation even worse. Under Cornell, a plaintiff can survive a motion to dismiss by simply saying that a plan hired a service provider, which all plans do. The next step in litigation is discovery, which can cost defendants around $10 million. So the plaintiffs offer to settle, say for $6 million. The plaintiff's lawyers walk away with a third of that, $2 million. And participants really get next to nothing. And all they've done, all the plaintiff's attorneys have done, is filed a boilerplate complaint. And this can be repeated all over the country with the exact same result. And that means the cost of plans and the availability of services and products in those plans and the outcomes reduced for participants are all hurt participants, including future participants. The fine bill, in our view, is essential as a first step in addressing the crisis. Thank you for your time. Happy to answer questions.
Thank you, Mrs. Dudley. Now, Mr. Rivera, we welcome you for your testimony.
Good morning. Thank you. Mr. Chairman, members of the subcommittee. Thank you for inviting me to testify today. As Senior Vice President for Litigation at AARP Foundation, I am honored to speak on behalf of AARP, which advocates for the 125 million Americans aged 50 and older. Retirees depend on their retirement accounts in order to live, and America is facing a retirement crisis. Most adults worry about having enough money to be financially secure in retirement, and Congress should focus on ensuring their retirement savings are protected. The Supreme Court's recent decision in Cunningham versus Cornell is much more than a technical interpretation of ERISA. It is a strong reminder of Congress's intent to protect the retirement security of millions of hardworking Americans. We've moved away from the old days of guaranteed pensions to plans like 401ks, where folks are now expected to shoulder more of the responsibility and bear the risk for their own retirement. That's why ERISA exists, to make sure the people managing these plans play by the rules. They're required to put workers first, act with common sense, and handle your hard-earned savings with prudence, loyalty, and care. For everyday retirees, these protections are not abstract. They mean the difference between a dignified retirement and financial hardship. When plan managers cut corners, like pushing high-fee investments or ignoring costs, it can drain tens of thousands of dollars from a worker's retirement savings over time. When fiduciaries prioritize their own interests, savers suffer lower returns and face higher costs. ERISA gives savers the power to fight back and ensure accountability. The Supreme Court's unanimous decision, let me repeat that, unanimous decision in Cunningham reaffirms ERISA's foundational promise. Plan fiduciaries must act prudently and loyally, and beneficiaries' only redress is often meaningful access to the courts to enforce those duties. The court made it clear, to state a claim under ERISA, a plaintiff need only plausibly allege the elements of a prohibited transaction, just like any other case. The burden of proving exemptions belongs to the defendant, as Congress intended. This restores the balance between everyday Americans and large financial firms, ensuring that allegations of conflicted transactions receive judicial scrutiny rather than being dismissed on technicalities. Why does this matter? Because ERISA is not just a statute, it is a promise that when workers put their hard-earned money into retirement plans, those assets will be managed prudently and loyally. If unnecessary procedural barriers prevent claims from being heard, that promise is broken. The The significance of this decision cannot be overstated. For most Americans, their retirement savings represent their life's work. Take one of our clients, Brian Byrne, for example. Brian was a retirement saver who alleges his plan fiduciaries violated their obligations by carrying out prohibited transactions. For Brian, a disabled veteran, the accumulated losses could be life-changing. When companies mismanage retirement assets and seek to maximize their own profit by charging people like Brian exorbitant fees, they jeopardize the retirement security of older adults, particularly harming low and moderate income workers. There are millions of other Brians out there. Some have claimed that the Cunningham decision will invite a flood of so-called frivolous ERISA lawsuits, burdening plans and fiduciaries. These concerns are overstated and ignore the data. Far from being frivolous, these cases often uncover real harm, leading to reforms like fee reductions and improved investment menus. That is not a decision to be taken lightly to bring a case in the first place. The people who pursue these cases are doing so to recover money that was siphoned away by those they entrusted to look after it. It is money that is rightfully theirs. Giving workers the right to fight back isn't a threat to retirement security. It's the very thing that protects it. Congress should stand firm and reject any attempt to pile more burdens on America's working class or weaken their ability to enforce their rights. AARP urges the subcommittee to make sure participants can protect their hard-earned life savings under ERISA, keeping fiduciaries honest and fostering a more secure retirement system for all Americans. Thank you for holding this hearing and allowing me to speak. I look forward to answering your questions.
Thank you, Mr. Rivera. Now I recognize Mr. Butash for your testimony.
Thank you. Chairman Walberg, Ranking Member Scott, and Ranking Member DeSaulnier, and members of the subcommittee, thank you for the opportunity to testify today. My name is Glenn Butash, and I'm chair of the ERIC Legal Center, part of the ERISA Industry Committee, or ERIC. ERIC is a national advocacy organization representing the interests of some of the largest employee benefit plan sponsors in the United States. The ERIC Legal Center advances policy positions on behalf of its members in the courts, primarily through the filing of amicus curiae briefs in cases that raise significant legal issues. Over the past 15 years, there's been a surge of cases brought by a handful of class action law firms against benefit plans and their fiduciaries. According to one recent study, since 2016, more than half of plans with more than $1 billion in assets have been targeted for litigation, some more than once. These are plans maintained by sponsors like ERIC's member companies that devote significant resources and attention to complying with the law. The barely veiled secret is that these suits are designed to generate a quick settlement, often with merely token recoveries for plan participants. And if there's no quick settlement and the case survives a motion to dismiss, discovery and litigation costs can run into the millions of dollars. This has real consequences. In addition to the hard costs, litigation expense and increased liability insurance costs, there are soft costs as well. The distraction of plan professionals, plan administrators, and plan investment teams who need now to gather documents and respond to discovery in the lawsuit. And there's also the very real potential to distort fiduciary decision-making, which would be an unintended result. All of this is to the detriment of the retirement system that protects so many American workers. ERIC strongly supports common sense litigation to address this issue. First, Congress should address the Supreme Court's decision in Cunningham v. Cornell and require, in any case that alleges that the engagement of a plan service provider constituted a prohibited transaction, also to allege why the exemption that Congress wrote for reasonable contracts or arrangements with service providers does not apply. Second, Congress should require, in any case relating to plan costs or plan investments, that the plaintiff plead a meaningful, context-specific benchmark, genuinely supporting an inference that the plan fiduciary's process was flawed. And third, discovery should be stayed while any motion to dismiss is pending. Notably, None of these changes would detract from the right of plan participants who are genuinely aggrieved to have their day in court. I welcome your questions. Thank you.
Thank you, sir. And now, under Committee Rule 9, we will question witnesses under the 5-minute rule. I will recognize myself for 5 minutes. Mr. Salakram, we have heard testimony today that predatory class action attorneys are targeting large employee benefit plans and large employers for quick dollar settlements. In your experience, what percentage of the plans and fiduciaries that you have represented in litigation operated prior to the litigation with teams of experts to ensure they meet their fiduciary duties?
Well, I'm trying to think of an exception, and I can't, so I'll say 100% or very nearly 100%.
Would you say that the plan and fiduciaries that are being sued are compliant with the law?
Absolutely. ERISA, and as the Supreme Court has acknowledged, requires fiduciaries to make difficult trade-offs, and fiduciaries can make a wide range of decisions that are reasonable. And the vast majority of fiduciaries, in my experience, are doing their very best, considering appropriate information, consulting with experts to arrive at reasonable decisions that are in participants' best interest.
Is it safe to say that it's not breaches of the fiduciary duty that are attracting class action lawsuits, but rather it is the pools of money in these plans that attract class action lawsuits?
That's accurate. Plaintiffs typically target the largest plans they can find with the most participants in them. Those large plans bring with them the potential for larger damages arguments from the plaintiff side, and also often come with larger insurance policies. And plaintiffs are laser focused on insurance policies and settlement discussions and in mediations. They really make no secret that it's less about the merits and more about how can I compel you, impose discovery costs that will compel you to turn over your insurance policy in a settlement.
So when these settlements are reached, does it benefit the 401k employees and their plans, or does it benefit the company who's providing funds, matching funds for those plans, or do the lawyers get all the money?
The lawyers benefit for sure. They,
And you're guilty until you prove you're innocent.
That is
pretty much.
That is the
That's
result.
not jurisprudence at all. That's not how our country operates.
Correct.
Thank you. Mr. Biddish, I understand that as chair of the ERIC Legal Center, you have seen dozens, if not hundreds, of frivolous class action lawsuits filed against large employers and large plan fiduciaries. What percentage of these lawsuits were copycat or boilerplate allegations seeking a quick settlement?
So I can't give you an exact percentage, but I do know that in certain areas that has been the focus of these lawsuits, when you read that a new complaint has been filed, and I will go and I'll read the complaint, and it sounds very familiar, and a lot of the allegations are not defendant specific, but they present the arguments that you see in each of these cases. So they tend to be very cookie-cutter lawsuits with very little defendant-specific research.
Would you explain what you have seen with respect to frivolous class action lawsuits? Can you give us some examples?
We're seeing there's been an enormous number of cases relating to plan costs, obviously, plan record-keeping costs, but also investment costs. There are also tons of cases relating to the use of plan forfeitures in 401k plans, and the argument that there was a breach of fiduciary duty in the use of those forfeitures, even though the plan document permits using them for such things as defraying and employer contributions.
Ms. Dudley, you have 36 seconds. You look like you need to add something to this
I do.
Discussion.
Well, the thing that I would add, in the 43 years I have worked with plan sponsors, I have never seen litigation like it is today. It is exponentially more. And the number of cases that are what I refer to as frivolous because they're just repetitive copycats. You'll see a dozen of essentially the same complaint filed, spattered across the country, and it might be forfeitures, or it might be fees, or it might be underperformance, or it might be any one of these things, or it might date back to some transaction that occurred in 1989. I mean, it is just across the board, and it is exponential in impact on the plans.
Thank you. I now recognize Ms. Saunier, our ranking member, for the purpose of questioning the witnesses.
Thank you, Mr. Chairman. I think we're all agreed, since I'm not an attorney, that we could, no offense to any attorneys who are in a position of leadership on this committee, but we could use less attorneys and lawsuits. And in that regard, this subcommittee heard testimony from the head of EPSA recently that they only had one investigator for every 14,000 health plans. So it strikes me that we could actually do something constructive by getting more investigators. So before we have the lawsuit, we could come to a conclusion and enforce the existing laws, or where there are gaps. During Bush, too, we were promised that these kind of investments and movements in Americans' retirement plans to 401ks would benefit everybody. And the facts that we have in front of us, that is not what has come to fruition. As a former small business employer, this doesn't help the American workforce in terms of its security. People under 40 don't have retirement accounts, and their ability to move up and get wages and be able to contribute has diminished in the last 2 decades. Mr. Rivera, thank you for being here. Hardly a radical organization are coming here and expressing its feelings. Could you tell us just this decision, this unanimous decision, how important it is for the financial stability of American workers in retirements, and enforcing it in a way that makes these investments safer, not at higher risk?
It's incredibly valuable to American workers and savers. The resetting and leveling of that playing field that had previously been split often against workers and retirees is now restored. And again, it was 9-0. For a Supreme Court that doesn't often agree, let alone unanimously, I think it's pretty clear. And they agreed not only that this is what the law said, but also that it made sense given the kinds of transactions that we're talking about here. These are prohibited transactions, not questionable, not we might want to think about this a little harder transactions. These are prohibited transactions. And Congress prohibited them for a reason, because they're generally not going to be good. But they give the opportunity for the defendants to be able to demonstrate in those rare circumstances that they might meet an exception. But that's exactly the way it should play out, because having the burden placed on the retiree or the beneficiary doesn't make any sense when it comes to these kinds of claims, where you are talking about somebody who has breached the trust that you have placed in them to take care of your retirement. And the information that might be relevant to any of those exceptions to what are otherwise prohibited transactions lie in the hands of the other party. So Justice Sotomayor, on behalf of the entire court, noted that it made little sense to put that burden on the retiree, and instead to have it, as the court decided, with the burden ultimately for proving those affirmative defenses on the industry. Because what matters here is the risk that is borne by the beneficiary by having bad decisions made on its behalf. The GAO has reported several times about how even a small difference in fees may have a significant impact in the long term.
Mr. Rivera, we have numbers that middle-income Americans have on an average about $65,000 in retirement savings. The lowest quarter of Americans have 0. So Americans are working longer. We've had a 40% increase in the last 10 years of people over 65 continuing to work full-time. Could you address that? Your members are working longer and harder because they cannot retire.
That's a significant problem. There is a retirement crisis in the United States. People are living longer, which is generally good. People are working longer, both by choice and by need. But to your point, the amount of money that people have saved to be able to live when they cannot or no longer are able or willing to work simply isn't enough for them to carry on. So the importance of preserving retirements through ERISA and the ability to use the tools that Congress created to protect those savings are incredibly important for their financial security and to protect them from having to rely on public assistance or other changes later.
Thank you, Mr. Rivera. Thank you to all the witnesses again, and thank you, Mr. Chairman. I yield back.
The gentleman yields, and I now call on our esteemed chairman, Mr. Wahlberg, for 5 minutes of questioning.
Thank you, Mr. Chairman, and thanks to the panel for being here. ERISA, I guess in comparison, ERISA, like farm credit, has been an amazing factor for retirement and for planning for retirement, for giving employees and business owners an opportunity to combine and work together and offer choices. And I think it's a truth that alternative assets or assets that are private offerings offer competitive returns and opportunities for diversification for 401k investors. That being said, on August 7th, President Trump issued an executive order on democratizing access to alternative assets for 401k investors. The order stated that, and I quote, "burdensome lawsuits that seek to challenge reasonable decisions by loyal, regulated fiduciaries have denied millions of Americans opportunities to benefit from investment in alternative assets," end quote. Mr. Selleck-Ram, could you discuss whether burdensome lawsuits are discouraging 401k fiduciaries from innovations such as alternative assets that could improve retirement outcomes?
Fiduciaries operate in a challenging, complex environment. They're presented with ever-changing facts and circumstances that, as you say, require innovation and creative solutions so that participants obtain the benefits of their retirement plans. And fiduciaries who are seeking to innovate are threatened by meritless, frivolous lawsuits in the same way that fiduciaries who are engaging in the more mundane aspects of plan administration are threatened. They're all threatened. The litigation is a powerful disincentive to fiduciaries to make innovative choices and come up with creative solutions, certainly.
Okay. Mrs. Dudley, could you answer that same question from your experience?
It's a great question, Mr. Chairman. Recently,
Microphone.
Oh, sorry. We recently conducted an informal survey of our plan sponsor members, and almost 89% of the defined contribution plan sponsors noted that the risk of litigation is a significant factor in their decision to offer services and investment options or products to their participants. So it is the impact of and the risk of litigation is affecting plan sponsors and their decision and their ability to offer a wider range of services and benefits to their participants, and that hurts participants, that hurts everybody.
And not a risk of legitimate litigation.
This is not legitimate. If you have a legitimate claim, nothing anybody is suggesting here would affect that. If you have a process-based violation that you need to bring to the court, overriding the Cornell decision does not prevent you from taking that to court.
Okay. Mr. Butash, I detect that you'd like to answer the same question if you could indeed discuss whether burdensome lawsuits are discouraging innovations. Microphone.
Thank you. Mr. Chairman, I think the litigation environment does discourage innovation. It tells fiduciaries, even though they know they are supposed to act in the best interest of participants and with the duty of prudence and loyalty, it does tell them that if in certain areas, if I make this particular decision, there's the potential for a lawsuit. And we would be naive to think that that doesn't color some of their analysis. I think the issue goes beyond the issue of alternatives, which is a very common asset class. Every DB plan owns alternative growth assets in their portfolios. To me personally, adding that to a 401k fund it shouldn't be that controversial, but it extends to many other areas as well, such as the ability to offer lifetime income as a distribution option in a defined contribution plan. I mean, that's difficult to do, and I think that the risk of litigation is serving as a brake on some of those innovations which would benefit retirees.
Okay. Well, I appreciate the answers, and I think we want to foster that competition for the good and for the benefit. And litigation, though necessary at times, certainly is, in my mind, prohibitive when it's abused. Mr. Chairman, I yield back.
I thank the chairman, and now I call on Mrs. McBath, Representative McBath from the great state of Georgia.
Thank you, Mr. Chair. Thank you so much, each and every one of you, for joining us this morning, and I have read your testimonies. Although I don't have any formal questions for you today, I would just want to caution that in the climate that we're in financially, a lot of Americans are very considerate about every penny. They want to make sure they're not losing any pennies. They want to make sure that their investment for retirement is funded, fully funded and protected. So I think that we need to make sure that we're not erroneously saying that people are deliberately filing frivolous claims, because oftentimes when it is their life savings, it's critically important to them, even though the fiduciary may not think so. But instead of taking action to ensure that every American has access to a plan that will provide a decent life for themselves and for their families in retirement, my House Republican colleagues are pushing legislation that directly undermines everyday Americans' ability to be able to defend their legal rights in court. They aren't undermining just any legal rights here either. They are trying to chip away at the American people's ability to protect what they have fought a lifetime for and what they have earned and saved for themselves and for their families. The efforts supported by my Republican colleagues will only make it far more difficult for working families to protect what little they may have saved over a lifetime of being underpaid for the value that they create on a job. They would tip the scales even further against the American workers in favor of their employers by automatically giving the benefit of the doubt to an employer over the employee, even though the employee is the one who may have been wronged here. Instead of allowing the legal system to play out and an employee to have their day in court to make their case, it would make it more difficult and even impossible for workers to get the justice that they are due, justice that they have every right to seek, and even a familial responsibility to pursue for themselves and for their families that are relying on them to provide for them. Instead of looking at these cases on their individual merits or evaluating them on a case-by-case basis, House Republicans want these decisions to be made in favor of large corporations before the legal system even has a chance to begin. That's the real purpose of these efforts here today. The real purpose is not to protect retirement benefits for workers at all. House Republicans just claim that to be their intent because the American people would never really knowingly support something that takes their rights away and hands them over to the corporate giants who already have millions of dollars and armies of well-trained lawyers at their disposal. Instead of being straightforward about their intent, they tell half-truths about what is really going on in order to push an agenda that is good for the wealthy and the powerful, but bad for regular people. If Republicans wanted to support Americans in retirement, they would protect Medicare and Social Security, not call them entitlements. If they really wanted to protect Americans from having to unexpectedly go back to work in their 70s and their 80s, they would raise the minimum wage. They would stop cutting food aid and scholarship dollars for the poorest American families so that they can try to justify billions of dollars more in tax breaks to the well-connected and the most powerful in our society. Just like Social Security and Medicare, Americans pay for their retirement in each and every one of their paychecks. They earn it every single day at work, and it is dishonest to imply otherwise. The proposals brought forth by the majority are Republican tactics to try to trick the American people into believing that the money that you earned and that you saved, that money that you paid into the system, isn't really yours to benefit from. They're trying to convince you that they pay you to give up your fund, that they pay you, they're trying to convince you that the pay you give up to fund your Social Security and your retirement doesn't really belong to you at all. There's nothing that you can expect to do about it if the money you put away for your future is being mismanaged. It's another attempt by House Republicans to break the promises made to you by your government for generations. There's so much that we could be doing to help Americans reach retirement instead of the proposals that the majority is putting forward here today. Simply, we need to stop playing games with the American public and the hard-earned money that they've put away. I encourage all of us here to focus our efforts on solutions that will truly make Americans' lives easier and better going forward. I yield.
Thank the gentlelady from Georgia. And just for our witnesses, I just need to clarify the purpose is, as we understand it, is that the employees are not suing the employers here. It is the law firms that are benefiting from this process. That's what this hearing is about. So just to clarify that, just a point of order there. I now call on Mr. Unger for his line of questioning for 5 minutes.
Thank you, Mr. Chairman. And thank you for all the witnesses coming here before the subcommittee today. As a physician, improving our nation's healthcare system has been one of my top priorities. And a lot of this discussion today is centered around employer-sponsored defined contribution pensions. But I'd like to also learn more about how Congressman Fine's ERISA Litigation Reform Act could affect health plans and health plan litigation. I understand that the primary intent of this bill is, again, the former, mostly pertaining to record keeping or excessive investment management fees. But I'm curious about how this would impact both frivolous and legitimate lawsuits related to health benefits. For example, some employees have sued over their employers' plans under the ERISA statute for allegedly mismanaging the prescription drug benefits, such as Lewandowski v. Johnson & Johnson. That class action lawsuit was dismissed due to the plaintiff's failure to adequately allege Article III standing. Mr. Salem Baham, in your experience, are the majority of plaintiffs' lawsuits against health plan fiduciaries dismissed for lack of standing?
Well, we've certainly started to see the plaintiffs' bar bleed into the healthcare space, and you're absolutely right. There have been several such lawsuits, essentially copycat lawsuits, trying to copy what has been done in the retirement space into the healthcare space. And you are correct. There have been dismissals based on standing.
Is it generally over okay? And are they usually filed over fees or over?
Yes, it can be related to fees. It can be related to the benefits provided based on different plan options. Correct.
Okay. I'm curious also about the interaction of this bill with self-insured health coverage. Self-insurance, of course, is a very popular alternative where the employer provides, takes actuarial risk and provides health insurance to his employees, often with reinsurance. Earlier this year, the committee marked up my bill, the Self-Insurance Protection Act, which would preserve access to this option that lowers health costs and improves quality for employers and employees. Mrs. Dudley, could you speak to whether Congressman Fine's bill would affect the self-insurance, health coverage system in any way?
Well, the important thing about Representative Fine's bill is that it overrides the Supreme Court decision in Cornell. And in that particular decision, anyone who hires a service provider, if a plan sponsor hires a service provider, you're violating ERISA, and you survive the motion to dismiss. But all plans use service providers. You have to use service providers. And so if you survive that motion to dismiss, you're in the discovery, the period of discovery. That is not, even a motion to dismiss can be upwards of $1 million to deal with a motion to dismiss. And then discovery can be upwards of $10 million. And what it does, and it would affect all plan sponsors because it puts pressure on companies to have settlements, and it inhibits innovation and the ability to provide services to people. It's not preventing, it's not trying to stop legitimate claims, it's addressing a problem.
And thank you. And Mr. Butesh, I'd like to ask you a couple of questions. You testified that there's been a trend in increased frivolous lawsuits over defined benefit contribution plans. Have you seen a similar trend in health plans as well, self-insured health plans?
It's just beginning, and it's something that we are watching at the Eric Legal Center. We've been very active as an amicus in filing cases trying to protect ERISA preemption from state court encroachment on uniform benefits law. That's a big issue. I know it's not the topic for today, but we're monitoring the healthcare cases to see what trends might develop.
And that was a point of my Self-Insurance Protection Act as well, to prevent the states from encroaching upon reinsurance, which is essential for most employers to provide employer-provided coverage. Yes. So thank you very much. I yield back.
Thank the gentleman for yielding. Now I call on Mrs. Mannion from New York.
Thank you, Mr. Chair.
Representative Mannion, I'm sorry.
Thank you. Thank you, Mr. Chair. Thank you to our witnesses. I'm glad to be here today to talk about the financial security of American workers and ensuring that employee benefits, including health and retirement benefits, are fully protected. When ERISA was signed into law over 50 years ago, Congress made an essential commitment to safeguard workers' hard-earned benefits and to ensure plan managers and fiduciaries operate by the highest standards. Over the years, Congress has worked to strengthen ERISA's provisions and protect the interests of plan participants and beneficiaries. And just this year, the Supreme Court, in a unanimous decision, reaffirmed workers' rights to have their day in court and recover what they've been owed when their retirement plan is mismanaged. Despite it being a unanimous decision, some members of the House and this committee have taken issue with it. We've heard a lot of attacks from the other side that class action lawsuits brought by employees are frivolous. And here today, some have suggested that the ERISA legislation does not benefit plan participants at all, but rather their attorneys. I was a teacher association president representing professionals, teachers, nurses, school psychologists, almost 400 of them over the course of 8 years. And in my experience with them, when individuals were impacted, they were simply trying to protect their livelihoods and hold fiduciaries accountable. Mr. Rivera, you've heard these same claims here today and before, that the ones that are benefiting most from ERISA litigation are the plaintiff's attorneys. And is in support of this view, what has been cited is that they believe that the settlements are often small for what is recovered for plan participants. So given your experience in supporting workers who have been harmed, could you respond to the claims that we've heard today and talk about some of the victims in the cases that you've worked with?
Sure. There is no question that strong enforcement of ERISA has led to better outcomes for plan participants and savers. This is true not only because of the important watchdog function that ERISA allows the beneficiaries to play on behalf of themselves and the plan itself, right? This is a feature, not a bug, to have private enforcement to ensure fiduciary duties are kept. But importantly, in addition to the funds that are recovered for the individuals, which of course, when you total them in any given case, are going to be the vast majority of dollars recovered. So it's a little disingenuous to talk about the total recovery for the attorneys versus an individual when you have to multiply that by 300,000 or however many hundreds of thousands of people were harmed by the practices at issue in that case. But more importantly, what we see is behavioral change as a result of those cases. It's not just about the money, it's about the practices. It's about competing so that the fees that you charge are lower. As a result of litigation over the history of ERISA, the fees are lower for plan administration and investment. There are better practices with respect to due diligence. There's greater competition so that the ultimate beneficiaries here are the plan and the plan beneficiaries.
Thank you, Mr. Rivera. I yield back.
Thank the gentleman for yielding, and now I'll call on Representative McKenzie for your 5 minutes of questioning.
Thank you, Mr. Chairman, and I appreciate the topic of today's hearing. Very important that we do focus on the benefits that American workers have earned and they deserve, and making sure that fees aren't excessive, that lawsuits aren't frivolous, and that ultimately that money makes its way back to those American workers so that they can enjoy their retirement. Just a couple quick questions that I have for the panelists. The first is for Mr. Butash. I understand from your bio that you've practiced ERISA law for almost 40 years. Have you seen this being a trend of frivolous class action lawsuits over your career and during the last decade? Is that a trend line that you're seeing an increase of these?
I think there has been. Trying to think back to earlier in my career, the types of ERISA litigation cases that I saw and read about, and they seemed, there were different focuses at different times, but there didn't seem to be this deluge of cases. And again, I comment that they seem to be largely brought by, a handful of the same law firms, and so they're recycling the same pleading against deep-pocketed defendants or large plans in the views of getting a quick settlement. If I may, Ranking Member DeSaulnier mentioned the number of investigators at the DOL compared to the number of benefit plans, and it's important to remember litigation is not an investigation tool. You're supposed to have a claim before you file your complaint. And I think one of the key problems with the pleading standard in general, and with the Cornell decision in particular, is that what the Supreme Court said in that case is when a plan is engaging a service provider, which all benefit plans do, I think it's almost would be imprudent not to engage professional record keeper, professional asset manager. What the Supreme Court said is that if you want to allege that that's a prohibited transaction, all you have to allege is that the fiduciary hired a service provider to provide services to the plan, and instead the burden then shifts to the defendant to prove that it meets the exemption for reasonable contracts or arrangements with service providers. So I appreciate that that was a 9-0 decision, and I'm not quarreling with the legal analysis of that decision, but the result is I don't know what adjective to describe, but and it would not be novel for Congress to step in after a Supreme Court decision and to return expectations to where they were. There was a case back in the early 90s called Harris Trust that unsettled all expectations in the particular issue that was at issue in Harris Trust. And a few years later, Congress passed legislation to address the Harris Trust decision. So we really commend Representative Fine's bill for addressing the Cornell decision in a way that we think is very responsible and really doesn't detract from aggrieved participants to bring a claim where there's genuine harm that they are aware of.
And time is running down, so I'll go to Ms. Dudley here. Regarding President Trump's executive order on August 7th about litigation risks that impede American workers' retirement accounts from achieving competitive returns and the assets diversification necessary to secure a dignified retirement, what are examples that you see of threats from these lawsuits that are being brought by a small number of law firms, as was just stated, against these defendants? What do you see that the result is on stifling innovation or making changes for employee benefit plans that actually don't benefit the employees?
Absolutely, great question. Again, we conducted an informal survey. Risk of litigation is a key, a significant factor in their decision to offer new services or benefits. Almost 89% said that of defined contribution plan sponsors. Almost 29% of our plan sponsors that answered the survey say they won't offer something new unless other people are doing it. Almost 25% say they will not offer, have decided not to offer more assistance because of the risk of litigation, and almost 43% say they will not provide lifetime income because of the risk of litigation. I mean, it's very serious.
Those are serious findings. I appreciate you bringing them to us. Obviously, again, we want to make sure that there is the appropriate amount of flexibility and innovation in the market for these employee benefit plans because, again, as the markets change, we need to adapt to make sure that workers have the benefits in their retirement that they not only deserve, but they've earned over the years. So I want to thank all of you again, and I yield back to the chair.
I thank the gentleman for yielding. Now I call on Mrs. Hayes, Connecticut, for your line of questioning for 5 minutes.
Thank you. This hearing reflects a pattern by the Trump administration and Republicans to attack the regulatory and legal frameworks that protect the retirement benefits of workers. In America, you should be able to retire with dignity if you work hard and play by the rules. Preparing for retirement is incredibly important and often requires assistance from financial professionals. In April 2024, the Biden administration finalized a retirement security rule that would protect American workers and retirees by requiring financial advisors to act in the best interest of their clients. This rule would have addressed a deceitful practice in which a financial advisor could steer clients toward investments that were more lucrative for the advisor but not in the best interest of the clients. While most financial advisors are working in the best interests of their clients, this problem costs retirement plan participants as much as $17 billion a year. Unfortunately, the Trump administration and Republicans are working to rescind the retirement security rule. Last week, the Department of Labor withdrew its appeal defending the rule in court, paving the way for the administration to abandon the rule altogether. Mr. Rivera, can you explain how the actions by the Department of Labor to rescind the retirement security rule would impact workers and retirees?
Well, the retirement security rule is something that AARP certainly had supported. And I think the importance of fiduciary duties can't be overstated to protecting American retirees. So just as we're discussing here today, the American worker is really help them navigate their risk of choosing how their money is saved and invested. And so it is important for us to make sure that they have all of the tools and all of the protections necessary, given that we are operating in a system where individuals are taking on greater risk and greater responsibility for their own retirement.
Thank you. In your testimony, you also stated that, quote, Congress should not tinker with what the Supreme Court unanimously decided in Cunningham versus Cornell, which ensures that allegations of conflicted transactions receive judicial scrutiny rather than being dismissed on technicalities that deny workers their day in court. Can you tell us why any legislative attempt to overturn or narrow the holding announced in that case would directly undermine the core protections of ERISA and impose greater harm and risk to retirement beneficiaries? And what are some actions that Congress could take to ensure that the workers retire with their dignity and the benefits that they've earned?
Well, there's certainly a lot of room for improvement for the retirement savings of American people to be protected and to grow. The standard here that the Supreme Court announced is really important for American workers because it does make sure that, as we said earlier, these transactions are per se problematic. Those are the words that the unanimous court used in its opinion. These particular transactions present so much risk of harm to the individual savers that you generally can't do them. There may be certain exceptions under certain circumstances based largely on information that may be solely in the possession of the fiduciaries, but nevertheless, it's important to make sure that the retiree savings are as strongly protected as possible.
I think you said something very important, the individuals. And for so many people, it takes a lot of trust to hand over your retirement savings to someone, and you just operate with the assumption that they're working in good faith and in your best interests. And I think on this committee, we should be focused on protecting the American workers and retirees, ensuring that there's both transparency and accountability in the way these plans play out, because for the average person, they wouldn't have all of this fiduciary knowledge to understand the impact, the long-term impact of all of these things. And we actually have the ability on this committee to focus on protecting the retirees who literally have saved this money to secure a thriving retirement. With that, I yield back.
I thank the gentlelady for yielding, and now recognize Representative Fine, who we've talked about quite a bit this morning, for your 5 minutes of questioning.
Well, thank you, Mr. Chairman, and hopefully some of it's a little good. It'd be a nice change. I want to thank you all for having the hearing today on an issue that I think is very important to people's lives, and featuring this issue and talking about my bill, House Bill 6084. We've all experienced this issue in our own lives. Leave ERISA out of it. Think about going through your mail on the average Saturday and you find some notice about some lawsuit that's happened that you didn't even know about, you didn't know there was an issue, you get a check for $7.23, and if you actually read the notice, you find out that the law firm that brought this claim is going to get $5, $10, $15 million for getting you your $7.23. Well, it's one thing when that happens in some sort of generic part of your life, but it's another when it happens when it comes to your retirement that you are depending on to take care of you when your working years are over. And that is why this bill is so important. But let me be clear, no industry has a monopoly on jerks. And I actually usually use another word when I say that. There are bad actors that need to be sued. But there are also plenty of bad lawyers who take advantage of the system. And what my bill intends to do is to strike that balance, to give people the opportunity to sue when that bad actor does take place, but also to protect people from having their retirement savings sucked away from unscrupulous lawyers. So I do have a few questions. I want to start with Mr. Butash. In your testimony, you gave an example sort of like the one I talked about, where participants got under $20 each. That ain't going to save your retirement, while lawyers took nearly $500,000 in fees. Gives that lawyer a pretty good retirement. Is that the purpose of ERISA, to help lawyers retire with $500,000 fees while people get $20? And is that an outlier or typical of how these cases resolve?
So that's not the purpose of ERISA. I think class action lawyers, in cases that aren't designed just to yield a quick settlement, are looking to be compensated for their efforts. typically we do see, and I don't know why the industry has stuck on this, but they typically take a third of the recovery. So imagine, if you will, and you know, the cases are legion. Every week or so you can read about a settlement, and it's a recent case, and it's settling at, you know, $2 or $3 or $4 million. And that lawyer is going to take a third of that, and then the rest of it is going to be divided among the 50 or 75,000 participants in that plan. And recall, too, that these are fiduciary cases. The statute of limitations under ERISA is 6 years, so they're getting $50, but that's to cover the alleged wrong covering 6 years. So it really is like the example that you gave where you get your $7 check in the mail.
And keep in mind, the reason it's a third is there's no one really to negotiate. In most of these instances, the law firm is coming up with the case. They're finding a couple people who are willing to be the primary plaintiffs, but it's not as though some guy who's in the ERISA plan is hunting for a law firm to get him the $20. That's why the fees never go down. Ms. Dudley, you mentioned a tidal wave of frivolous litigation draining resources from workers' retirement accounts. In your view, how urgently is congressional action needed, and what risks do workers face if Congress fails to pass my bill, which is, again, the ERISA litigation reform, H.R. 6084?
To me, I think it's extremely urgent.
That's the right
I
answer,
think
but
this,
thank you.
I think this is really important, and I'm so appreciative of the hearing and the opportunity to talk with everyone about this. Under the current law, based on the Supreme Court decision, the plaintiffs' attorneys can go out, gather up their plaintiffs, file their claims, and file a whole lot of them at once, and compel settlements very quickly because of the cost. And even just the motion to dismiss is expensive, and then you get to discovery, and that's extremely expensive. And what this does is it makes plan sponsors have to pull back and limit what they can do, and then it scares participants, and then they don't contribute, and they don't engage in the plan. Overall, it's very urgent.
And I would close just by noting the cost of this is not just the money that's going to the plaintiff's attorney. We can focus on the $500,000, but the defense costs that the plan has to pay, which could be $1 million, $2 or $3, that never shows up anywhere. So it's a third of the settlement goes to the plaintiff's attorney. It could be an equal amount that the company spent fighting it until they decided it just wasn't worth it to settle. This is hurting our retirees. We owe it to them to protect them. I appreciate the hearing, and I hope we'll get my bill moving. Thank you for being here. I yield back.
I thank the gentleman for yielding. Now I call on my good friend, Mr. Courtney, for your line of questioning.
Thank you, Mr. Chairman. Again, as somebody who practiced law for 27 years before I came to Congress, I was actually quite sort of curious about this hearing because I actually hadn't been following this case, but seeing a unanimous decision by the Supreme Court and also a very interesting discussion of the federal Rules of Civil Procedure, Section 7, in the both the concurring opinion and the prevailing opinion. I'm really struggling, honestly, and Ms. Dudley, I've worked with the Benefits Council a number of years, have a lot of, respect and admiration for the work that they do, but I honestly feel that the reaction to this decision is way over the top. And I'm not the only one. Jones Day, which is a highly respected law firm here in Washington, D.C., does a lot of defense work for companies in this type of litigation. They published an article after the court decided its case in which it said that the U.S. Supreme Court encourages Federal Rule 7A7 replies, which is a way to screen out meritless complaints before discovery. Again, I want to be really clear here because it was both the majority opinion and the concurring opinion by Alito that laid out the roadmap for defense counsel in terms of getting swiftly to a judgment on a meritless claim, and again, in accordance with the ruling that was handed down. And, Mr. Rivera, I just want to make sure, I'm not reading Jones Day's analysis wrong. The fact of the matter is that, again, they gave a very clear, somewhat not used much in the past because they didn't have to use it, okay? What the court is really saying to defense counsel is that, you know, you have to kind of hustle a little bit, you know, in terms of the pleadings pre-discovery to get to the place where a motion for judgment can actually be heard. Mr. Rivera, maybe you can respond to that opinion of the court's decision.
Sure. I think the court, both in the unanimous decision as well as in the concurrence, offer a number of different ways. The concurrence highlights the Rule 7, as you said, to reply to an answer. But the court said there are other tools in addition to Rule 7, and that Rule 7 hasn't been commonly used doesn't mean it's not viable. To your point, hasn't needed to be used, or people haven't really thought about it very much. Use it. Let's see what happens with that on both sides and see how that process plays out. But the court acknowledged you have the opportunity to have a reply, make sure there's standing question, if there's a question of the parties standing to sue, there's sanctions for bad faith cases, truly frivolous cases. There are real remedies and disincentives to bring a truly frivolous case as opposed to one where people may reasonably differ. As a lawyer, you would know not every case is going to be everybody agrees, oh, this is clearly right, this is clearly wrong. There are going to be places for that kind of case management that enables frivolous suits to be.
Well, thank you for, again, just sort of reminding us that the court just didn't sort of throw the doors open to Lionel Hutz from The Simpsons to come rushing into court and try and, you know, get judgments, you know, that are undeserved. I mean, the fact of the matter is they laid out a responsible legal process for a swift judgment on meritless claims. Mr. Chairman, I would ask that, again, the Jones Day analysis of this decision, which again describes it as a potential boon for defense counsel in terms of getting the desired result, which we've been listening to in this hearing this morning.
Without objection.
And, you know, again, if we override this, and again, believe me, there's a lot of Supreme Court cases I'd love for us to be holding hearings on in terms of having Congress, you know, take action. Citizens United is obviously right there at the top of the list, which damage it's done to our elections and political process. But the fact is that we've got a case that is literally, the ink is barely dry on this decision. I mean, it was last spring that it was handed down. There clearly is disagreement, legal disagreement, about whether or not the witness's position today is that it's, you know, going to create this crisis, or whether or not it's actually going to help the system weed out meritless claims. And I think, again, we are rushing ahead with a legislation on an issue that is far from a crisis. I yield back.
Thank the gentleman for yielding. Now I call on our esteemed Chairman Emeritus of this great committee, Mrs. Fox from North Carolina, for her 5 minutes of questioning.
Thank you, Mr. Chairman. I appreciate this, and I appreciate your holding this important hearing. Mr. Salik Rahman, in your testimony, you give examples that border on outright harassment, including plaintiff's counsel suing a defendant's infant grandchild and serving process on the baby's home. What does this willingness to target anyone even loosely connected to a plan, up to and including minors, tell us about how unrestrained and unprincipled some of these litigation strategies have become? And what message does that send to employers who are trying to provide voluntary benefits in good faith?
Certainly, it's an example of the non-monetary burdens that defendants in these cases, who are people, individuals, face. And so that was one of the more egregious examples, but certainly there are any number of examples of discovery abuses, including, you know, naming as many defendants as possible to increase the financial burdens on plan sponsors, to ratchet up settlement pressure, as well as just, you know, the volumes and volumes of discovery that can be issued that can ratchet up legal fees. So it's a real burden, and it's done intentionally by the plaintiff's bar, again, to extract those cost of defense settlements.
Well, I want to follow up a little bit on that. As you know, ERISA is a protective statute that Congress passed to protect the benefits of American workers and their families. Could you discuss whether the litigation reforms discussed today, such as stays on discovery or modifications to pleading standards would undermine those protections?
No, they would not undermine those protections. In fact, I think they would enhance them. The concern is that meritless, frivolous lawsuits, if allowed to continue, and it's not just starting with Cunningham, this has been years of them, if allowed to continue, will impact plan sponsor and fiduciary behaviors. Plan sponsors could decide that it's not worth it to offer benefits anymore, or they may offer less lucrative benefits given the costs of defending these lawsuits. Or they may change their behavior. They may think, I would like to engage a particular service provider who I think would be best suited for my particular plan, but they're not the absolute cheapest, and that makes me nervous that I might get sued. And so maybe there's an incentive to make a fiduciary choice that the fiduciary doesn't believe is actually in its participants' best interests. So I think that by eliminating these frivolous lawsuits, you're actually enhancing protections for American workers.
Thank you. And again, I want to get some amplification on what you just said from Mr. Butash. You state in your testimony in today's environment, fiduciaries might avoid choosing providers or funds that offer richer services or better long-term value simply because they fear becoming litigation targets, as Mr. Salik Rahman just said. Can you explain how this threat of becoming the target of litigation for choosing anything but the cheapest possible option undermines the quality of retirement plans and the outcomes workers rely on?
So ERISA can, I believe, and does recognize that when a fiduciary is making a decision, there are a range of reasonable options, a range of reasonable decisions that fiduciary can make. Unfortunately, with the pleading standard the way it is, despite efforts with Supreme Court cases, the Dudenhofer case, the Northwestern case, we're still getting these cases where the pleading standard is exceedingly low, and that is causing this added cost that is disruptive to retirement plans in the United States.
Thank you very much. Mrs. Dudley, predatory lawsuits contain baseless accusations. How do these accusations undermine employee confidence in the benefits provided by an employer?
They do undermine that. That's a good question, too. They do undermine the confidence of the employee because they erode trust. A lot of times these settlements, and that's really what's happening here with the frivolous lawsuits, is they're trying to drive to a settlement. And settlements maybe look like somebody did something wrong, even if what the company was trying to do was settle it so that it didn't continue to drain resources. Remember, those resources are not just the time and the commitment from the HR and the benefits staff, but it's also paid for out of the budget and reduces the future compensation and money available for benefits. And so it looks like somebody did something wrong when in fact they didn't. They were just trying to be practical, and it causes employees not to engage in the plan.
Thank you very much, and thank you, Mr. Chairman, again. I appreciate our witnesses. I yield back.
Gentlelady yields, and now I'll call on Mrs. Lee from Pennsylvania for your line of questions for 5 minutes.
Thank you, Mr. Chair. My Republican colleagues on this committee have held hearing after hearing and introduced bill after bill benefiting employers and their profits at the direct expense of workers' rights and workers' ability to meet their basic needs. And here we are again with a hearing, another hearing about how to further undermine workers by limiting their ability to make claim to the retirement benefits that they are legally entitled to. My Republican colleagues have referred to workers' ERISA lawsuits as frivolous, but with an administration that has shown complete disregard for worker protections, from undercutting the Employee Benefits Security Administration to trying to eliminate the Consumer Financial Protection Bureau altogether. How can we call workers who are using what little resources and recourse they have left to address valid complaints about excessive fees or questionable pension investments frivolous? with an administration that issued an executive order to facilitate 401k investments in private equity and cryptocurrency, it's hard to believe that workers might be facing real issues with their retirement funds caught up in risky investment options. I don't think it is. It's the very people waging the attacks on workers who are alleging that workers are complaining too much about being attacked. And they would have us believe that it's the volume of the complaints that we need to address, not the fundamental attacks that they're facing. Despite the fact that the volume isn't even high, with about 100 class action lawsuits a year for over 800,000 ERISA-covered retirement plans, workers' concerns are very real. Yet the significant harms to workers posed by high fees, by fiduciary breaches, are completely absent from Republican talking points. Instead, the focus is solely on the alleged harm being done to big corporations, the health insurance companies, and corporate defense attorneys. Mr. Rivera, in your experience with ERISA lawsuits, are the corporations being sued suffering more than the workers and senior citizens who are suing them?
No, clearly we're talking about the brunt of the challenges here falling upon beneficiaries and retirees. They bring the cases because they have obviously a deep stake in their financial future. This is about the people at the end of the day. They need the lawyers to access the system because that is the tool that they have that Congress has created to ensure that fiduciary duties are enforced and honored, and as a way to get behavior change when organizations do the wrong thing.
So when a class action lawsuit has been successful, what has it meant for the workers and the senior citizens who are part of the suits?
Lower fees, better investment choices, among other things, being able to reduce the cost of different kinds of investment, greater practices internally with respect to due diligence, to competitive bidding for the services that they need, all of the things that have helped to make the process better and safer for retirees and savers.
Thank you. So the real story here is that when workers and senior citizens experience very real harms to their retirement savings, the ability to exercise their legal rights can be the difference between retirement security or financial ruin. But instead of focusing on how to protect workers and senior citizens' rights, especially from an administration working to undermine them, we have Republicans and our allies in business pushing to overturn a unanimous Supreme Court decision to make it even harder for the workers to exercise their legal rights under ERISA. Mr. Rivera, should the folks who AARP represents, the 100 million Americans who are at least 50 years old, feel secure about their retirement prospects with the direction that the administration and the Republicans are taking us in?
Well, it's very clear that the people who have retirement savings, workers, future beneficiaries, retirees, need to have every tool available to them, including access to the courts, to be able to make sure that their hard-earned savings are well protected and that they can have as much trust in their fiduciaries as possible.
So maybe. I appreciate that. And I appreciate your testimony. Republicans already passed the largest cuts to SNAP, to Medicaid in history, and now it's clear that they want to go after folks' retirement benefits too, and that is a deep concern. We all have senior citizens in our lives, and one day we too will be retiring, and we want to know that we can do that with dignity, and we can do it without financial ruin. Americans work a lifetime to earn the right to retire with that, and we must do everything in our power to protect it. So I thank you all so much, and I yield back.
I thank the gentlelady for yielding. Now I call on my friend, the ranking member of this committee, Representative Scott, for his 5 minutes of questioning.
Thank you, Mr. Chairman, and I yield 30 seconds to the gentlelady from Georgia.
Thank you to my colleague from Virginia. I would like to respectfully respond to comments that were made by Chairman Allen earlier that the employees are not suing and that the lawyers are just benefiting on their own. The lawyers are clearly suing on a plaintiff's behalf, so I wanted to clarify that I believe that this was just a difference of opinion between us on this issue that doesn't rise to a point of order. And I believe my comments were accurate to what we are discussing today, and I want to make that clear before we conclude today, and I yield. back to the
Thank
gentleman
you.
from Virginia.
Reclaiming my time, Ms. Dudley mentioned that 89% of the participants consider being sued as they make their decisions. Apparently, it's worked because according to the statistics that the ranking member cited, 99.9% of the plans, in fact, did not get sued between 2020 and 2024. So this hearing is about the 1 out of 1,000 that I guess did get sued. Mr. Riviera, we heard a lot about these copycat lawsuits. I remember when I was practicing law, if I filed a divorce suit, each one looked remarkably like the last one I filed on exactly the same grounds. Should we be surprised that a case based on excessive fees should look much different than the last case based on excessive fees?
I would expect that there would be similarities in a lot of those kinds of cases if there are similar allegations in terms of the particular provisions of ERISA that one is challenging.
Thank you. And Cunningham v. Cornell found that the claim of exemption was an affirmative defense. Is there anything in the federal rules of civil procedure regarding affirmative defenses that is peculiar to ERISA cases that wouldn't apply to just about every other case?
Nope.
We've heard about lawyers getting paid. In fact, we heard from the gentleman from Florida that participants got $20 and the lawyers got $500,000. Raises the question, well, you can rip your participants off clearly up to $20 to avoid the lawyer getting paid. There must be some threshold where you can get ripped off. Obviously, the only way you can stop the misconduct is these lawsuits. So I guess my question is, should the plan pay the legal fees or the guilty fiduciaries who've been profiting from their misdeeds pay the legal fees?
Well, it certainly sounds like it should be the ones who did something wrong.
Okay, well, Mr. Butash and Ms. Dudley, can you name specific examples of lawsuits that were in fact frivolous that were brought against some of your member organizations?
Well, I don't think today I would name names and name specific lawsuits. I do know that there have been just a whole range of copycat lawsuits, and I'll be happy to come back to you with more specifics on these, but...
Okay, but if you're not going to name, Mr. Butash, can you come up with examples of cases that are frivolous, and maybe even some against your members that were meritorious?
I don't have that information for you. I will say, though, ERISA reflects a careful balancing, and participants do need the right to get the benefits that are promised to them. But also, we shouldn't have a system that's so complex or so costly that it discourages employers from creating and maintaining employee benefit plans in the first place. It's a voluntary system.
Well, thank you. Mr. Riviera, can you cite examples of meritorious cases that have been brought that have stopped abuse?
So there are a lot of cases that have settled, right? And in most of those cases, well, all those cases, no one admits any wrongdoing. But you have seen, as a result of cases, changes to plan behavior that over time, as you look at the industry, have definitely led to reduced fees, greater transparency, and better choices for the plan beneficiaries.
And excuse me, if I could just add and finish my sentence. There is a good example out of the Second Circuit where the court had to revive a case based on the Cornell decision, even though they had dismissed it as baseless. So it is happening. There are lots of suits that I would deem frivolous or I would deem baseless, or courts have decided are baseless, that now will be reopened just because of the Cornell decision.
Thank you, Mr. Chairman. I yield back.
All right, the gentleman yields back, and All right. All right. It looks like we're finished up here, and I'll call on our ranking member, my friend, Mr. Saunier, for your closing statement.
Thank you, Mr. Chairman. And again, as we often talk in our relationship here, more than happy to engage in a discussion about making the system more efficient and making sure that Americans' retirements are protected. In 1989, if my number is right here, just a second. In 1989, almost half of Americans were in a defined benefit plan. As we've moved away from that to more creative solutions, we have more pressure. That's why people are working longer, and there's more pressure on people, in addition to the fact that the cost of things continue to go up. So squeeze is harder and harder. So I'm happy to work with you as two people who've met in our other careers, thousands of payrolls and contributions, to make the system more efficient. So Americans, workers, and retirees are facing a crisis thanks to the current, my perspective, administration's economic policies. The cost of living, as I've said, continues to rise. The job market has slowed, financial markets are suffering, and worker protections have been stripped away. Today's hearings and subcommittee's agenda this year have regrettably, in my opinion, focused on chipping away bedrock regulatory and legal frameworks protecting workers' retirement and health care benefits. Earlier this year, the committee advanced two partisan bills that tipped the scales against workers in favor of bad actors, not all employers, but the most egregious ones. The bills do nothing to support EBSA's key mission at a time when it is understaffed and under-resourced. And today's hearings unfortunately shows that my committee colleagues do not want to stop there. Even though the facts show that the volume of ERISA class action litigation is incredibly small compared to the total number of retirement plans. Again, be happy to work with the witnesses and my colleagues to eliminate the inefficiencies. But overall, we have to be more aggressive to protect American workers' retirement plans efficiently. We should be working together to strengthen and expand ERISA's protections and not undermine them. I thank the witnesses and yield back.
I thank the gentleman for yielding, and now I'll recognize myself for a closing statement. I want to thank our witnesses again for your expert testimony. Frivolous lawsuits impose serious financial and reputational costs on employers, and I stand by that statement. Ultimately, these lawsuits suck up time and resources that should be spent helping Americans save. Some class action lawyers have spawned a litigation racket exploiting ERISA to extract massive settlements without merit. Meanwhile, employees, employers, and retirees all lose out as legal fees soar, resources are drained, and their optimal investment risk are at risk. ERISA was designed to protect retirement savings, not to bankroll a business model for opportunistic lawyers. H.R. 6084, the ERISA Litigation Reform Act, which we discussed today, protects the retirement system from predatory lawsuits that are bleeding employers and feeding on benefits meant for employees. And Mr. Saunier, I'll be happy to work with you on that legislation so that we can solve this problem and move on to the myriad of other issues that are facing the American people. I would again like to thank all of our witnesses and that testified before the committee, and without objection, there being no further business, the subcommittee stands adjourned.